The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have three cases that will be considered this morning. They are Tina Haskenhoff versus Homeland Energy Solutions. The second case is Auto Owners Insurance Company versus Iowa Insurance Division. And the final case is Dennis Smith versus Iowa State University of Science and Technology. That last case is now submitted to the court without an argument, and we'll hear now the arguments in the first case. Mr. Visser.
Good morning. A plaintiff may choose the theories under which she elects to proceed. This case, however, illustrates what happens when the plaintiff is allowed to pick and choose, swap in and out the elements of the theories under which she proceeds. The harassment theory probably illustrates this the best and is the most far-ranging in terms of impact in this case. The question placed before this jury wasn't whether there was prospectively offensive speech and actions which were taken. The question was whether the employer promptly and effectively remediated the conduct which was reported. That question was never presented to the jury to be decided. Instead, the plaintiff has advanced what it is calling a negligence theory, a theory that they claim has been, I believe, lying in repose for the past 18 years since Farragher and Ellerth were decided and settled the area of law. This theory has now risen, according to the plaintiffs. They've submitted it, omitting the key elements of that employers have been relying upon everywhere. A question that exists is, why would a plaintiff want to do this? Because Farragher and Ellerth introduced a quick path to vicarious liability for conduct of a supervisor, which is offensive in nature.
What do you make of the statement in the recent Vance case? It says, as an initial matter, an employer will always be liable when its negligence leads to the creation or continuation of a hostile work environment.
What I make of that is that cert was granted and Vance was decided on one question, which is, what's a supervisor for applying our two standards?
But it seems to suggest, that there are two potential theories of liability, one being I'll call it, and the Supreme Court seems to call it, a negligence theory. The other theory is more of an agency theory, vicarious liability, Farragher, Ellerth. And as I read the Ball statement, and it's a brief statement, there's no exegesis. And indeed, as I look through the cases, there's a number of brief statements kind of like this.
Right.
But it seems to set up two different theories of liability, a negligence theory and a vicarious liability theory. And if I understand your argument, you're saying, that dichotomy really isn't right. There's but one theory.
It's not right at all, and I wondered the same thing, Justice Apple. So I went back and looked at the Seventh Circuit decision that was left alone, and what Justice Alito referred to. It's a coworker theory, but he referred to it as a negligence theory. And that Seventh Circuit decision that remained undisturbed granted summary judgment to the employer on the coworker theory on the basis that the plaintiff had failed to establish that the employer not remediated, not to give a double or triple negative there. So even what's referred to, if you want to take these little bits of language that have been cited as a negligence standard, when you look back at what the writer of that was writing about, he was writing about the same co-work standard that has its genesis in the Ellerth case, which has the best reasoning by
Counsel, after Vance, has any court squarely held that you can only use a vicarious liability theory to challenge supervisor harassment, that the negligence theory is not an option?
the coworker theory is the theory that it is, and I think the Ellerth case takes special pains to point out that common law principles, if we're calling it negligence, only go so far in their particulars. I'm not aware of any case that says that you can't, nor am I aware of any case that says that you can. What we have to remember here is that jury trials in sex harassment cases didn't start coming into being until 1993 or 1994, after the passage of the 1991 Civil Rights Act, which made these jury triable. There were only a few cases. There were some cases decided between 1994 and 1998, which gave rise to mass confusion. 8 opinions on the Seventh Circuit's decision on Ellerth alone. The court sought to harmonize that. This court adopted the reasoning of Ellerth and Farragher in Farmland Foods, and it also adopted that reasoning in McElroy and other cases.
Well,
I'm unaware of any jury ever being instructed as this jury was instructed, anywhere, any court.
You're correct, I think, in saying that the snippets of negligence that we see in the case law generally refers to co-workers. But wouldn't it also apply if you negligently hired supervisors, for example? Or aren't supervisors co-workers too? I mean, I didn't find, and maybe I missed it, of course, I didn't find a case that expressly linked the negligence theory with supervisor actions. Maybe it's out there, but I didn't find it. I did find the cases that linked negligence theory with co-workers. But it seems to me if you have a negligence theory for co-workers, why wouldn't you also have a negligence theory, I guess, for supervisors too?
That's the argument that Justice Thomas put forth in his dissent that completely rejected that notion in 1998. The whole idea, what employers relied upon back then, before Farragher and Ellerth, was this: the general rule is that sexual harassment by a supervisor is not conduct within the scope of employment.
But that's a negligence theory, right? I mean, I'm sorry, a vicarious liability theory. When a supervisor engages and acts within the scope of employment, ordinarily there's vicarious liability for the employer. And the question is, what's within the scope of employment? That strikes me as a vicarious liability type analysis and not a negligence analysis. Can you help me out?
I'm not sure that I can, but what I can tell you is that employers relied upon the notion that nothing that anyone does, if it's sex harassment, is inside the scope of their job duties as a way to escape and avoid liability. And this is something that the plaintiff's bar was quite opposed to, obviously, and advocating for the whole vicarious liability notion as it pertains to supervisors. Justice Thomas argued, well, if the supervisor's negligent, the supervisors are negligent as well, negligent in hiring. But he also provided the escape clause. So if we're going back in this time machine to negligence days, what we also get with it is, well, even if the supervisor did it, he wasn't supposed to be doing it. And I don't think the plaintiffs want that. This is very plaintiff-friendly law.
We have to read the instructions as a whole, and what about instruction 24 that defines remedial action?
Instruction 24 is tethered to nothing, Your Honor. It's floating around out there in the universe, along with instruction 22 that talks about the existence of official policies. And this is where the plaintiffs loaded in their theory through the use of their expert witness to come in and talk about what a reasonable employer did and didn't do, shouldn't do, and that's what the standard should be, which then became the law of this case.
So what's missing from the marshalling instruction is in letting the jury know on a what you call the co-employee or negligence theory that the plaintiff has to prove that the employer failed to take remedial action.
Employer knew or should have known and failed to take prompt remedial action. It's in every case this court has decided.
But that is different from the language that Justice Apple quoted in Vance, right? Vance kind of allows you, and their instruction tracked that language in Vance literally, right?
That part of the marshalling instruction does quote the language of Vance, but it does away with what Vance didn't touch. Look at the dissent in Vance and the majority in Vance. They both acknowledge
is it kind of
these
your, I mean, I've certainly been guilty of this. Is it kind of your position that Justice Alito was using poor language in that part of the opinion when he said, as an initial matter, an employer will always be liable when its negligence leads to the creation or continuation of a hostile work environment? Because if that's right, and if that's Iowa law, their instruction tracked that.
I think that it's really just a ramp up when you look at the parsed language that's quoted. What it's talking about is the common elements, if you will. If they want to talk about negligence, there's negligence in terms of having the offensive conduct. It's unwelcome. It's objectively and subjectively inappropriate. Then it goes to the basis of employer liability. You have to look at the entire decision of Vance, and again, both the majority and the dissent completely embrace the notion that different standards apply. And they don't attempt to redefine the standard. Nothing in Vance attempts to redefine the standard for imposing liability in either coworker or supervisor cases.
Could you address the other, what you allege are instructional errors requiring a new trial? For example, is it your position, Iowa law, for retaliation, the causation element, it must be the protected conduct must be a substantial factor, and here the court, the instructions given drop the word substantial, just a factor or plays a part. Is that reversible error?
It is, and the retaliation instruction has two very significant problems. Problem number one is this causation standard difference. The previous cases, the Nassar case, which is a federal case which talks about retaliation, shows that there's really but-for causation that needs to be established for the policy reasons that are discussed in our brief. It's the type of situation, like the facts lent credence to here, where the employee might be in a little hot water, the employee plays the complaint card. It's the difference between the status-based discrimination, where the retaliation is based upon an immutable characteristic, and conduct-based difference. And the adverse action instruction is also very problematic instruction number 3.
Let me go back to that issue you were just talking about on the causation. I mean, how do you respond to their argument? I didn't really detect a response to their argument that the same causation language is used in the discrimination and in the retaliation portions of the Iowa Civil Rights Act.
There's going to be a disconnect somewhere, and the way the law is now is that the same type of but-for causation that's used in retaliatory discharge cases is also used in retaliation cases under the Civil Rights Act. And that's also consistent with what is used in the federal retaliation cases for the policy reasons that are stated. So it's going to be either inconsistent with that, or it's going to be inconsistent with the played-apart standard, which is due to the status-based discrimination. The adverse action instruction, very problematic. Look how loaded that thing is. There's the standard language about what shouldn't be, and then fact-specific commentary in this case. Reprimands or threat of reprimands, a change of opportunities, false accusations or complaints, being investigated, being placed on a performance improvement plan. That's not in our law. The only thing they left out is your name Tina, and did you work in Chickasaw County? This was totally loaded up. There's virtually with nothing to argue. The constructive discharge instruction as well. The plaintiffs could have won this case fair and square, but they chose to alter every single one of these instructions. Constructive discharge, they insert a subjective provision that the conduct this person experienced must have been subjectively offensive or difficult or hard for her to deal with. This omits, it includes the statement that the employer need not want the plaintiff to have quit. That's nowhere in our law.
Isn't that a correct statement of law?
It's an incomplete statement of the law. I don't think it's necessarily incorrect, but it's incomplete. If we wanted to be complete, we would have included the language that the language cannot be deemed intolerable unless the employer gets a reasonable chance to resolve the problem. That's what this case was tried about. This employee was invited to come forward with complaints on August 17th.
So did you request on this jury instruction that has the business about the employer need not intend the employee to quit? You requested additional language that the district court declined to give?
We certainly did. The employer was effectively in a position where it couldn't be heard. At the outset of the case, Homeland said there's 3 questions that need to be answered. This is page 406 or 407 of the transcript. They each included, did the employer take prompt and effective remedial action where the situation's so intolerable that the employer didn't have a chance to deal with it? And would the same decision have been made to reprimand the employee had the complaint never occurred? When we got to the end of the trial, none of those were submitted for consideration by the jury. The defendant in this case needed to have an opportunity to have its conduct judged according to the law that's been put forward and been relied upon consistently for the last 18 years. The harassment piece is a very far-ranging issue. There's obviously an entire cottage industry. It's not just the litigants who are dispossessed. It's in any law firm of any size has 1 or 2 or 3 people who advise employers, what do we need to do to deal with this common employment problem? You need to have a policy. You need to publish it. What if something comes up? You need to stop it. You need to get the harassment stopped. That's what this employer was supposed to be judged upon. We weren't arguing that some of the underlying conduct didn't occur. I'm past the stop point. Thank you.
Thank you as well, Mr. Visser. Ms. Conlin.
May it please the court, there are some inconvenient truths in this case, one of which is that the employer was itself negligent. That's the whole point of this case. It was the employer's actions that are at issue in a case involving negligence, and that's what this case involves. Did they, when they knew about the sexual harassment, make any attempt to stop it? Here is an inconvenient truth. She first reported this in November of 2010, 9 months before. Did they make any attempt to stop it? They made an attempt to stop her. They got her in a room.
I want to kind of divert a little bit from maybe the facts.
No.
And I want you to respond a little bit to the instructions themselves. I think clearly your argument is that the instructions are an accurate statement of what the law is, but I want you to respond to the comments that they're not complete. In other words, they don't have all the language in there. And I think that's where the crux of the entire defense appeal is that, sure, what's there may be accurate to the extent that it says it, but it's not the full story when it comes to what the law should be and what the defenses might be. So if you could respond to that for me.
Yes, of course, Your Honor. I believe that the instructions are complete, and the reason I believe that is because they set out explicitly in 7 different paragraphs what the law requires. And this is the significant thing about the instruction number 14 that was given by the court. The court says in number 7, Homeland Energy Solutions acted negligently, that's the employer, acted negligently in creating or continuing a hostile work environment. Creating or continuing. Those are the very words of Vance. Those are Justice Alito's words in the Vance case.
But is there a fatal omission in that instruction doesn't mention anything about the employer taking prompt remedial action?
Your Honor, that has no role in a negligence case. The defendants have come to rely on the Farragher-Ellerth test. Farragher-Ellerth permits plaintiffs to rely on strict liability, vicarious liability. And that means that we don't have to prove anything except when there's a tangible employment action. We have to prove that the person who did it or the person who caused it was a supervisor, then we win. We chose to proceed because there were both supervisors and co-workers involved, and to try to instruct on that would be a mess and confuse the jury. We chose to proceed entirely on the negligence theory.
Hypothetically, if they had fired Mr. Howes upon her first complaint in 2010, would she still have a lawsuit for the harassment she suffered initially?
Oh, I don't think so, Your Honor, and I think that...
Is that because they took prompt and effective remedial action?
Well, they removed him, which they should have done, from the work environment. They never removed him from the work environment. That is a hypothetical question. And
could you address the defense, or why is the defense wrong in saying that on a negligence theory, it's the plaintiff's burden to prove that the employer failed to take remedial and effective action to stop the harassment?
Because that's not one of the elements of a negligent case. We have to prove that the defendant, the employer, did not act in a reasonably prudent manner. That outrages the defendant. They think that's like a whole new standard. That is the standard we are all held to in our daily lives.
Would you agree that one goal of the Iowa Civil Rights Act is to encourage and give incentives to employers to, upon learning of harassment, to step in and stop it?
Yes, that's one of the goals.
Well, wouldn't we further that goal by allowing a defense at trial if upon learning of harassment they do come in and take effective measures to stop it?
That doesn't need to be a defense, Your Honor. That needs to be what a reasonable, prudent employer would do under the same or similar circumstances.
And is it the plaintiff's burden to prove that they failed to do that?
We undertook that burden in this case, Your Honor. We have a remedial action instruction. We proved they failed to take any action whatsoever.
But the instruction 24 that defines remedial action, it doesn't tell the jury what to do with that information. If we read these as a whole, but how does that fit in? So how do you address the defense argument that that issue wasn't decided by the jury?
That issue was decided by the jury under the section on retaliation and also under the section on sexual harassment. In fact, the jury had every piece that they needed to have. I think that it is important to recognize that we tried this case under a negligence standard. No part of the negligence standard is that they took prompt remedial action. All we have to prove is that they did not behave like a reasonably prudent employer would behave.
But isn't that, I mean, prior to Vance at least, under our case law, wouldn't you have to show in a negligence case that the employer knew or should have known of the harassment and failed to take proper remedial action?
Well, Your Honor, that's what the instruction says. Homeland knew or should have known of the occurrence of one or more sexually harassing incidents, and they acted negligently in creating or continuing a hostile work environment.
They argue the concepts are divorced. In other words, you don't have to show the connection. That the negligence occurred after the harassment, or after they knew or should have known of the harassment. That's when the negligence occurred. Whereas the more general statement that you had in there is acted negligently in creating or continuing a hostile work environment, which might be a broader concept than an inappropriate response.
Well, Your Honor, in the instructions that the instruction committee just drafted, they do not put anything in the supervisor instruction like knew or should have known or anything else. And we say those are, they're distinct theories of the case, and we get to choose. They do not get to choose what theory we proceed under, and so we choose negligence. We choose that so that we do not have this huge mess in terms of the jury instructions. And continuing means that they did not take action to stop it. That's what it means. They let it continue, and indeed they did let it continue.
What about creating, though?
And
That seems to be
creating?
a concept that maybe, arguably, or at least they argue, was not in the law prior to in our previous cases.
And that just confuses the heck out of me, Your Honor, because in fact it was in the law. It's in the law of this court. In the Lynch case, the very first case that reached the court in terms of sexual harassment, it was a part of that case, as it was a part of the Channon case, the McElroy case. There's a case called Madison versus IVP in the Eighth Circuit, which talks about creating the conditions. And again, we're talking about what the employer did or failed to do in this connection. I want to address just briefly Louise Fitzgerald's testimony, which they don't like at all. She is a person who did the original research in sexual harassment, who adopted and used the scientific method to prove or disprove what happens to women when they are sexually harassed. She used the scientific method to prove or disprove what works for an employer to do, or if they don't do it, what causes additional damage.
In our review for abuse of discretion, did her testimony ever cross the line into an impermissible legal conclusion?
Absolutely not, Your Honor.
Has any other court excluded her testimony?
I believe that her testimony was limited at the district court level in a case in Illinois, the name of which I'm sorry I can't remember. But she testified here in this state in Channon versus UPS. She testified here in this state in Madison versus IBP. So
Could you address the other potentially reversible jury instructional errors, the causation requirement, the instruction that you proposed and the court gave just referred to played a part and then a factor instead of substantial factor. Is that a problem?
Your Honor, no, I think it is not a problem as long as de Boom remains the law of this state. No, Your Honor, but the Iowa Civil Rights Act is a unitary act. It uses the same words. Unlike the federal act, it uses the same words to describe the causation factor under both the status, race, color, creed, and under the retaliation. It's because of. And Justice Strite, in his de Boom opinion, points out that we're all confused about, and we were, about motivating and determining factor. He chose motivating factor, and he said that means played a part. The federal cases are utterly useless at this point in the development of the Iowa Civil Rights Act because they do not, they provide no assistance in terms of what the causation standard is or ought to be. And in fact, in this retaliation case, played a part is exactly what de Boom says.
On the adverse employment action instruction, is there an Iowa case under the Iowa Civil Rights Act that says a reprimand is enough? Or does there have to be a financial consequence, a cut in pay, a lost promotion, or something like that?
No, Your Honor, absolutely not. The defendant says, for example, that there is absolutely nothing in the law that says that a person can be constructively discharged in a situation where they decided that their only alternative was to quit. That's just totally false. Van Meter says those exact words. The defendants requested instruction number 33 that has intolerable working conditions and all the things they love. instruction 34, we requested, and the judge gave them both. Both are accurate and complete statements of the law. I would have preferred not to have had instruction 33, and they would have preferred not to have instruction 34, and the jury decided this case. The jury worked very hard for 4 weeks to decide this very important case.
Conlin, one of the things we're taught when we write opinions is sort of not to try and restate our point several times, because there's always a danger when you restate it, you're going to state it a different way. And I have a little bit of that concern about instruction 33, that it kind of goes on and on and on, and a jury might potentially be confused and pick out different pieces of that and rely on different pieces of this instruction.
That was exactly my concern about 34, Your Honor. I mean 33. Let's see. 33 was the one they wanted. 34 was the one we wanted, and that I was worried that the jury would pick out some words in 33 deliberately makes the employees' working conditions intolerable, and they were worried that the jury might pick out words in instruction number 34, and the court held. I'm going to give them both. They're both correct statements of the law, and the jury will not be confused. And it doesn't appear to me that the jury was confused. In fact, Mr. Visser told the jury in his closing argument that the issue was credibility. Who do you believe? Because what Tina said was very different in many cases than what the defendants' representatives said. And the jury obviously accepted and believed and had every reason to accept and believe what Tina Haskenhoff said about her feelings, about what happened to her, and about what the consequences were. I have not had an opportunity to address the defendant's statements that we were negligent in asking questions that drew objections. There were 500 objections in this case, and we might argue that that was because the defendants were making so many objections. I'm sure that the court will be able to see that in many cases we simply rephrased the questions and were successful. So I think that at this point the very hardworking jury's verdict should be permitted to stand, as should the very experienced and somewhat conservative judge's award of attorney's fees. Thank you.
Ms. Conlin, thank you as well. Rebuttal argument, Mr. Visser?
Thank you, Your Honor. Shannon versus UPS defines what adverse action is, and I forgot whose question that was, but that talks about reprimands not being enough. And it goes along kind of with the notion of a tangible employment action being one of the employer's speeches. Dial was the case over in the federal courts in Illinois where Professor Fitzgerald's testimony was disallowed. I would note that the subject, the special limine motion to exclude that testimony, was what led to the recusal of the trial judge who had shepherded this case all the way through till 10 days before the initial trial date. And when the subject of ruling on whether she should be admitted or not, the judge determined that he should not be ruling on that subject. It was kicked to the new judge. The case was transferred. With respect to information from Professor Fitzgerald making its way into the jury instructions, we tried to compose a chart. We ended up using too many words, but we have cited that throughout the brief. And take a look at instruction 22. It's not just this marshalling instruction, number 14, but instruction 22 is drawn directly from and only from the testimony of Professor Fitzgerald, drawn from the guidance issued by the EEOC, which has been rejected when others have attempted to put it forward, including, I think, the court in Vance, rejected the EEOC's definition and guidance on this subject as hopelessly ambiguous. Vance, I would respectfully suggest, confirms, if anything, yeah, there are two theories that can be pled here. There's coworker, there's supervisor. Justice Alito referred to coworker as negligence. When you look how the majority and the dissent, including Justice Ginsburg's dissent, defines it. She refers to the notion of corrective action and remediation being a core part of that proof, because it is, as my colleague says, looking at the employer's conduct, but it's not looking at the employer's conduct through the prism of what a reasonable employer would do. What that does is it does violence to the entire notion of the law of employment discrimination, where an overriding theme is that judges and juries are not to serve as super personnel counsels. So now employers who are out there who are saying, what do we do? Who are picking up the phone when there's a complaint saying, how do we handle this? How do we get to the bottom of this? And our conduct's going to be judged based on how we have responded, are being told there's an entirely different standard, because if a plaintiff decides that he or she chooses to apply a different standard, well, they can just waltz into court and whatever a reasonable employer would do.
So your argument is under this create language, if that becomes kind of a standard. I mean, it seems here, based on the verdict, that a problem was created the minute this individual, Mr. House, was hired. And your argument is that's not enough to attach liability. Is that right?
That isn't enough to attach liability.
And that may be right, unless they were negligent in the hiring. I mean, there's a conceivably, I mean, I'm not saying that the facts in this case, I'm pursuing a theory, and that is a negligent hiring theory might well lead to liability.
Bring that theory. You're not going to prevail on this theory of sex-based harassment, though. This would completely upset the law, the standards, the expectations. Plaintiffs have...
No. I mean, I'm sorry, but we're not connecting. So let me try again. Suppose the facts showed negligent hiring of a number of supervisors, and that the facts showed that a reasonable employer would have done background checks and would have found out that there was a real problem of sexual harassment with their employers. Okay. Can the plaintiff then proceed on a negligence theory, saying that, well, the employer was negligent in not doing adequate background checks for the hiring of supervisors?
I don't think so. Ellerth is the fundamental jurisprudence and scholarship on that, and you can see how the court worked so hard to work through to find a unified standard that's been relied upon by every court, every jury, everywhere.
You make the point, and it's an interesting point, that ordinarily the vicarious liability theory is the easier theory. It seems to me.
It is.
Ordinarily, maybe not, but the plaintiff can still choose, if it's a viable legal theory, can still choose a more difficult theory, surely.
This allows the plaintiff to dodge the responsibility that she has and not to be judged on whether she took advantage of the complaints. If there were this gang of supervisors that were employed who were acting negligently, what the affirmative defense that's enshrined in the law permits is for the employer to say, this person negligently failed to come forward. She sat on it for 2.5 years, and then only after she stormed off the job and called her boss a bad name did she decide to come forward and articulate things. That's what's built into this. The question is, how did the employer respond to the complaint that was made? Not, was a hostile environment created way back in 1971? Now that I think about it, let's go find some unhappy employees and bring them in. Thank you very much.
Thank you as well, Mr. Visser. The case then is now submitted and will be in recess, but remain on the bench to allow the students and others to leave during or for the break.